Let's talk further about Australian constitutional law and explore the notion of constitutionalism. The idea of constitutionalism simply is that a government, which obviously wields political power, must be constrained by both formal and informal institutional checks and balances, and that government is conducted according to general laws that most people accept as legitimate. And a government that is committed to this form of government is said to be demonstrating the ideals of constitutionalism. And looking at constitutionalism, there are two key principles that we will find there. And one of them is the issue of rule of law, and the other one is the notion of legality. Let's begin by talking of the notion of legality. And the notion of legality simply means that any act that a political officer does or a government does must be according to law or based on law. It also means that from the viewpoint of people or the subjects of a government, they are actually allowed to do any act that the law does not forbid, and they may refuse or refrain from doing any act that the law does not require to be done. So what it means is that political officers or the government cannot do any act that is not authorized by law. If it is authorized by law, then anything that they do will be considered legal. One of the first cases that talks about the doctrine of legality is that 1765 case of Entick versus Carrington in the United Kingdom. And in that case, Camden, the Lord Chief Justice, said, "By the laws of England, every invasion of private property, be it ever so minute, is a trespass. No man can set his foot upon my ground without my license, but he is liable to an action though the damage be nothing. If he admits the fact, which is proved by every declaration in trespass, where the defendant is called upon to answer for bruising the grass and even treading upon the soil. If he admits the fact, he is bound to show by way of justification that some positive law has empowered or excused him. The justification is submitted to the judges who are to look into the books, and if such a justification can be maintained by the text of the statute law or by the principles of common law. If no excuse can be found or produced, the silence of the books is an authority against the defendant, and the plaintiff must have judgment." The common law doctrine of legality is actually part of a wider notion of the rule of law. The idea of legality, for example, is considered to be a minimalist concept of the rule of law in the sense that it is possible for acts which are deplorable to actually be lawful if they are authorized by a valid law. So, for example, a law may be passed that outlaws the practice of religion, or laws may be passed that prohibit the doing of certain acts, or laws may be passed that intrude into the private domain of individuals, including, for example, the wiretapping of phones or even the interception of emails and so on. In that case, if you follow the principles of legality, then those acts would be deemed lawful for as long as they are according to law, or they have been done in accordance with laws that have been duly enacted. The rule of law can actually, or ought to be understood actually, from the viewpoint of even a broader set of principles. And these principles are reflected in what has been written by Lon Fuller on the morality of law. And he says that a law that is moral actually has other qualities. And these qualities may include generality, publicity, prospectivity, clarity, consistency, publicity of compliance, constancy, and congruence of the law and its official administration. Let's try to look into this. It is important, therefore, to kind of look at the idea of the rule of law from these elements, in the sense that it can be argued that an act that has been done by political officers are actually legal. So they are covered by the idea of legality. And yet, if such laws have actually not been made accessible to the public, or if people are not made aware of the existence of such laws, then you can question the idea of whether or not the rule of law actually exists. If if the people in government actually wield the power to be able to enact secret laws that people are unaware of, then it puts into question the idea of constitutionalism and constitutional government, because if government officials or parliament is able to enact laws that people do not know of or are ignorant of, then it actually enhances their ability to abuse such a power and to put the rights and freedoms of their subjects at great peril.